and he fired shot after shot after shot.
Man, tell her the truth. Tell her the truth.
You had me tell my baby in the morning on her birthday Tyree was dead.
An intense day in a Kent County courtroom when a man, Jalil Hoskins, was sentenced to prison for taking the life of his girlfriend, Latrice Mays. Hoskins received a sentence of 50 to 100 years. In court, he confessed to disposing of her body near their Grand Rapids apartment. It was a highly emotional scene in the courtroom. Jalil Hoskins responds to hearing his prison sentence.
I love you, baby! I love you, Mom!
The sentencing concluded with Hoskins being quickly escorted out of the courtroom as both families erupted in loud shouting. Hoskins unexpectedly pleaded guilty during his murder trial. Mays, a mother of 5, went missing, and her body was never recovered. Hoskins admitted to disposing of her body. Before the emotional outburst, Mays' mother and aunt had the opportunity to face him in court.
You tell me how I explain what happened to their mom.
First of all, I want you to stand there and look at me and quit standing there looking at the ceiling like a little coward. You know, I'm going to face you and I'm going to tell you exactly how I feel.
Along with the second-degree murder charges, Hoskins was also found guilty of tampering with evidence for disposing of Mays' body. The gang-related shootings happened in Brooklyn, with one of the victims being a boy, tragically killed during a cookout in Bed-Stuy. Before the judge sentenced the 3 gang members to lengthy prison terms, the families of some victims shared their pain. From 2018 to July 2020, the Hoogly Street Gang was involved in a series of violent crimes across Brooklyn, shooting several people and causing 3 deaths. Now, these gang members will spend most of their lives in prison, but not before hearing emotional statements from the victims' families.
Austin, wish to make a statement?
No. The only word Deshaun Austin uttered before being sentenced to 50 years to life was brief. He was convicted of murdering 27-year-old Janelle Whitted in March 2020. Just 4 months later, Duval Gardner Jr. tragically lost his life during a family cookout near Raymond Bush Playground in Bed-Stuy.
We need to make an example out of him in case there are others that wish to follow in his footsteps.
The video captures Austin and another shooter firing several rounds into the playground, with bullets striking 4 people.
He's the one who had a gun and walked up to a playground where people were grilling, sitting next to a stroller, playing with their relatives, and he fired shot after shot after shot.
Months earlier, Whitted was followed by Austin after leaving a nightclub, where Austin shot him at close range. After a 6-month trial, Austin, along with Travis Scott, Jaquan Lane, and Akeem Artis, all members of a gang, were convicted on multiple charges, including several counts of second-degree murder and attempted murder. Artis received a 40-year sentence.
You had me tell my baby in the morning on her birthday Tyree was dead.
With 27 court officers present, gang leader Travis Scott was sentenced to 40 years for the 2018 killing of Tyree Walker. Walker, a 35-year-old father of 4, was shot while walking home despite having no connection to Scott. The families of all 3 victims have expressed that they now have a sense of closure.
But we're just happy today we got justice for the 22-month-old. We're just happy that this could be behind us and we can move forward with our lives.
Inside the courtroom, Walker's aunt spoke, but before leaving, she wanted to share one final message with the man responsible for taking the life of the father of 4.
And you's a hoolie? No, you's a hoodlum piece of dirt. Bye.
The atmosphere in the courtroom was filled with emotion as many were grieving their loved ones. The family of the boy did not attend or give an impact statement. As for Jaquan Lane, who was also involved in the murder of Janelle Whitted, he is scheduled to return to court for his sentencing. The driver accused of racing down Dale Mabry Highway and causing a crash that killed an innocent passenger will remain in jail for now. Tampa police are still searching for the other driver involved in the race. They are asking anyone with videos or information to come forward, and Conta are the ones who often suffer the most in these situations. When tragedy strikes, loved ones are left devastated. Linda's husband, who was driving the car, was taken to the hospital. Thankfully, he is expected to recover. there was an emotional outburst from a man pleading guilty to assault. Rodriguez was arrested in June 2017 after his son was found unresponsive at a home on Menlo Boulevard in the city's southeast side. As Rodriguez stood in court to face the charges, he also had some emotional responses of his own. Just minutes before being removed from the courtroom, Ignacio Rodriguez stood before the judge to face the charges against him.
Mr. Rodriguez, how do you plead? Guilty, not guilty, or no contest?
Guilty.
By pleading guilty to a lesser charge of intentional or knowing injury to a child, causing serious bodily injury, Rodriguez avoided a capital murder charge but still faced significant punishment.
It is the order of the court that you be sentenced to 50 years confinement.
Rodriguez could not escape the pain and heartbreak surrounding the case. The mother of the daughter expressed her deep sorrow and pain, letting him know just how much she was hurting.
I hate more than anything what you did to her son. And for that, I can't ever see myself forgiving you. You were supposed to be our protector, not the one to break our hearts.
However, when the mother began speaking, Rodriguez erupted into shouting, causing an emotional scene in the courtroom.
As she gets older, she will start asking questions.
Man, tell her the truth. Tell her the truth. Tell her the truth. Tell her how everything was supposed to be. Tell her the whole truth. Don't lie to her. Tell her the whole truth. Tell her the whole truth. Let's go. The whole truth.
Rodriguez was quickly escorted out of the courtroom following his outburst. A Harris County woman, Megan Fieramusca, who killed Austin's mother, Heidi Broussard, after kidnapping her and her daughter, has learned her fate. Attorneys reached a plea agreement in her capital murder case, resulting in a 55-year prison sentence. The judge described the crime as awful while delivering the sentence, which was significantly less than the life imprisonment she initially faced.
Then I never imagined.
Megan Fieramusca wiped away tears in a Travis County courtroom as the mother of the woman she killed, Heidi Broussard, spoke directly to her, sharing her grief and pain.
Love beyond measure, and she never gave up on anyone.
In December 2019, Heidi Broussard and her daughter, Margot, disappeared in Austin. A week later, investigators discovered Broussard in the trunk of a car parked outside Megan Fieramusca's home in northwest Harris County.
She was just so much fun, and she was so full of life. And now it's been taken.
Prosecutors originally charged Megan Fieramusca with capital murder, which could have resulted in life in prison without the possibility of parole. However, she pleaded guilty to a lesser charge of murder, which led to a reduced sentence.
We're really grateful to our law enforcement partners and to our prosecutors who helped win justice today and save the family from potentially decades of post-trial litigation.
Fieramusca's defense attorney stated that both parties agreed this resolution was the best way to avoid potential appeals. However, the sentence does nothing to ease the family's heartbreak and loss.
And we miss her dearly. She's forever strong in the midst of all of the people.
Megan Fieramusca, currently 37 years old, will receive credit for roughly 3 years already served. This means she will be eligible for parole in about 25 years. Mobile County now has its first female death row inmate. A mobile judge followed the jury's recommendation and sentenced Heather Lavelle Keaton to death. Keaton was convicted for the deaths of her 2 stepchildren, Natalie and Jonathan Chase DeBlas, 5 years ago. The sentencing marked the conclusion of an emotional case for the victims' family members.
Just remember their sweet personality and their loving nature.
2 little angels. That's how we want to remember them.
Prosecutors stated that Natalie and Jonathan DeBlase's lives were tragically cut short because they were murdered. Judge Roderick Stout ruled that Heather Keaton would join her common-law husband on death row.
She is a horrific person who could do these unimaginable things to children. I mean, duct tape, broomsticks, locked in suitcases and in closets, in the dark, alone, afraid, tortured, starved, poisoned, dehydrated.
A jury found Heather Keaton guilty of capital murder and manslaughter in the deaths of the 2 children.
It was a horrific act, and they deserve the death penalty.
Judge Stout reviewed 25 pages of facts before delivering his decision. These details revealed how Heather Keaton killed them. After their deaths, Keaton and DeBlas disposed of them near Van Cleve, Mississippi, and Citronelle, Alabama.
Can't deal with that right now.
At one point, the emotional details became too much for Corinne DeBlas, the children's birth mother, who left the room in tears. She returned when the judge began reading the sentence. Meanwhile, Heather Keaton remained still throughout the proceedings, speaking with her lawyer only a few times.
There is no winner in this. There's no winner at all. My brother and his wife lost their grandchildren, their son. She lost her life. She won't be able to raise her child. There is no winners.
Levelle Keaton, with her hair in a braided ponytail, showed no emotion during her sentencing. The family of a man who was killed faced a heartbreaking moment as the woman responsible, the mother of his child, learned her prison sentence. However, there was a surprising twist in the case from the victim's family.
Sentences be served consecutively.
Oh my God.
So we're talking about
my God.
In tears, Shaniqua Menefee learned her fate. The 35-year-old was sentenced to 15 years in prison for using her car as a weapon. She ran over Jamal Thompson, the father of her child, leading to his death.
My household is not the same. Like, she took a beautiful man. Me and him was together for over 10 years. And he never did nothing to me that make me want to do what she did.
In June 2023, Shaniqua Menefee and Jamal Thompson argued at her home around 2 a.m. When Thompson walked away, prosecutors say Menefee entered her car and followed him down the street. They continued arguing, and surveillance footage captured the tragic incident on 34th Street. The video shows Thompson sitting on a porch when Menefee rammed into him with her car. After the collision, she exited, walked home, and left him there. Thompson's final words before he died were captured, adding to the heartbreak of the incident. Shaniqua Menefee and Jamal Thompson had a child. Menefee claimed that Thompson had physically and emotionally abused her for years, which she argued contributed to the tragic events that unfolded.
I endured all this. I went and I took and got a protection order so that I could be protected. I was failed by the system.
Despite everything, Shaniqua Menefee expressed deep remorse for her actions.
I would like to apologize to the family, especially his mother, his kids. I can't imagine what they're going through.
During the court proceedings, Shaniqua Menefee's son spoke.
My mother never wanted any of this to happen. All she ever wanted to do was take care of me and my siblings.
In a surprising and emotional moment, Thompson's mother chose to forgive Shaniqua Menefee.
I don't know how it happened or why it happened, but I do forgive you because I have to do that for myself.
Shaniqua Menefee was sentenced to 15 years in prison, though she could serve additional time depending on her incarcerated behavior. Fawn Kim Seng was sentenced to 21 months in prison, bringing some closure to the case. However, for the victim's daughter, the resolution is bittersweet. Anna Nguyen disappeared in November 1998, and after leaving home, she was never seen or heard from again. Her vehicle was found in a parking lot a few days after she vanished, but her body was never recovered.
We don't know where she is.
Now, 24 years later, the final chapter of Anna Nguyen's disappearance has come to a close. The King County Medical Examiner's Office issued her death certificate in 2015, and her boyfriend, Fawn Kim Seng, was sentenced to 21 months for second-degree manslaughter in a King County courthouse. Seng was arrested in 2019. Kim Tien expressed relief and happiness that Seng was finally arrested.
Finally, we get the answers. It did take a while, but it's definitely, it happened. It's impossible for something like this to get away unnoticed. It just takes time.
Seng was initially charged with second-degree murder, but the charge was reduced to second-degree manslaughter. During the hearing, Seng was given the chance to address the court but chose not to speak. His defense argued that since the 1998 incident, Seng had lived as a law-abiding citizen, raising a family with children and grandchildren. However, in a statement read by prosecutors, Nguyen's daughter, Kim Tien, expressed that the punishment does not reflect the severity of the crime.
She understands the reasons we're doing it, but she does not agree with it. And she wanted to let the court know simply that she does not believe that justice was served for her mom.
In addition to his prison sentence, Seng will also be required to pay restitution to cover the fines related to the investigation. A key witness in the Northern Arizona University shooting trial, Nick Acevedo, has passed away, raising many questions as Stephen Jones's retrial approaches. The Northern Arizona University community is mourning Acevedo, an NAU senior, who was found by Flagstaff police in a home near the campus. Investigators believe Acevedo took his own life. He had witnessed the NAU shooting that occurred in the fall of 2015.
I ran up to the scene to grab Colin, and Stephen pointed at me.
Acevedo, seen here on the stand during the 2017 murder trial, was a key witness in the case.
I called him a freak. I called him a psychopath. And at that time, he started crying after that. And I picked up Colin and propped him on my leg and secured his wound.
The suspect, Stephen Jones, claimed self-defense when he shot 4 NAU students, killing 1. The trial ended in a mistrial, with the retrial scheduled. A Flagstaff criminal attorney and former state prosecutor mentioned that Acevedo's testimony might still be used during the retrial.
It may be possible to introduce his testimony from the previous trial.
Terry Hance stated that a pre-trial conference would likely be held if prosecutors intend to use Acevedo's sworn statement in the retrial.
It's really a court determination more than simply what the lawyers want to do.
The Coconino Medical Examiner's Office reported that the case had not yet been assigned, and it could take up to 6 weeks before Acevedo's cause of death is determined. The trial of rancher George Allan Kelly focuses on the killing of Gabriel Cuen Buitamea, with the key question being whether Kelly shot Buitamea from a long distance. Forensic pathologist Dr. Krista Tim reviewed the evidence extensively. The defense attorney used a model to review the bullet's path, questioning the absence of gunpowder burns, which could weaken the prosecution's case. A forensic scientist who tested samples from Buitamea's clothing also testified. However, the defense noted that the samples were collected by the case detective and pointed out that Buitamea's backpack had not been tested.
You were never given a backpack, were you?
I was not.
You received a jacket, correct?
I didn't receive the jacket. I received samples that were labeled as coming from the jacket.
How big are those samples?
They are small vials. They are the vials in front of me.
Can you hold one up again?
Yes. They're these small vials.
Does it tell you on those vials where it came from?
So that information was provided to me from Detective Barba. So the samples were labeled 1 through 5. He clarified to me which of each sample came from. So he clarified that 1 and 2 were from the jacket, 3 was from pants, 4 was from a shirt, and the 5th was a collection blank.
You don't know where on the item?
No.
And do you know the collection procedures that Detective Barba used?
I don't.
Or the determination of which samples to send to you?
No.
That's for Detective Barba, right?
Correct.
Your job was to look at those 5 vials and see if there's any shot residue, right?
Correct.
The jury may visit the ranch where the shooting took place, though that decision is still being discussed among the parties involved in the case. Laken Riley, a 20-year-old nursing student at Augusta University's Athens campus in Georgia, was admired for her dedication, kindness, and thoughtful personality. She often enjoyed running on a trail at the University of Georgia near her home. Tragically, her life was cut short on February 22, 2024, when she was killed during one of her routine runs. Riley's body was found that day in a wooded area close to the trail she frequently used. She had sustained multiple blunt force injuries and was suffocated. The shocking crime sparked widespread alarm and raised concerns about safety in the Athens community. The following day, February 23, 2024, University of Georgia police came across Jose Ibarra, a 26-year-old undocumented migrant from Venezuela. Sergeant Joshua Epps noticed scratches on Ibarra's arms, resembling marks made by fingernails. Investigators later discovered a navy blue jacket in a dumpster nearby, which provided critical DNA evidence linking both Ibarra and Riley. A blood-like stain on the jacket packet further supported the connection between them.
Do you swear from the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Please take a seat. State and spell your first and last name.
Ashley Hinkle, Ashley, Hinkle.
Where are you employed?
I'm employed at the Georgia Bureau of Investigation, the Division of Forensic Sciences in the Forensic Biology section in Decatur, Georgia.
How long have you been working there?
Approximately 18 years.
What is your title and your duties and responsibilities?
I'm a crime lab scientist. My duties and responsibilities include analyzing evidence for the presence of bodily fluids. If those are present, I attempt to obtain a DNA profile and compare that profile to reference sampled profiles that are collected directly from an individual. I'm also trained in a software program to analyze complex mixtures called TrueAllele.
What is your education and your training that qualifies you for your job?
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center. I have continuing education and proficiency testing on a yearly basis. I also have a approximately 1 year training initially in the TrueAllele software.
And that is initially, when were you first trained on the TrueAllele software?
2017.
How long was that training and what did it consist of?
It was approximately a year. It consisted of, we had a presentation from Dr. Perlin, who is the creator of the TrueAllele software. We read literature on TrueAllele and videos that were available. We had mock samples of known mixtures with known contributors, and we performed the testing from start to finish on those mock samples.
And so just to explain a little bit about that process, would that be like you taking my DNA and your DNA, mixing it together so you know it's mine and you know it's yours, and you know at what levels we both contributed, you would then test it in TrueAllele and see if it was accurate?
Yes, it's employee profiles mostly, and we can't practice on casework samples, so we have to use these type of samples for training.
So for training, y'all practice on yourselves, basically?
Yes.
Okay. And you did that for the TrueAllele software in this case as well, and you receive ongoing training?
Yes.
How many items of evidence have you had the opportunity to process for DNA in your career at the GBI?
In the thousands.
How many times have you testified as an expert in a court of law in the field of forensic serology, forensic DNA, and TrueAllele?
Approximately 300 times.
At this time, Your Honor, the state would tender Ms. Hinkle as an expert in the fields of forensic biology, forensic DNA, and TrueAllele.
Objection. I just renew all the motions that were involved in this, Judge, and reiterate that we don't have an expert in this case.
All right. I will allow the witness to testify in the other area of forensic biology, DNA profile comparison, TrueAllele software process.
I want to direct your attention to your case number 2024-1005107. Is that the case number associated with Laken Riley for the GBI?
Yes, it is.
And did you conduct DNA testing in this case?
Yes, I did.
And I want to go item by item to talk about which items you tested, what type of DNA testing you did, your methodologies that you used, and your results. But if you could first globally tell us what types of DNA testing are involved in this particular case with this case number?
The DNA testing consists of what we call traditional DNA testing, where we look at 21 locations along the DNA strand that we use to compare between individuals. Everyone should have a unique profile except for identical siblings. The next type of testing was YSTRs, where we look at 27 locations along the Y chromosome. This allows us to tell if a male individual is present or not present in a DNA mixture where there is too much female DNA that it overshadows the male profile. Also, true allele testing was used.
And in all the types of DNA testing, traditional, YSTR, and true allele, did you follow the GBI's policies and procedures as regards to each of those different types of DNA testing?
Yes, I did.
And of the methods that you used for traditional DNA, YSTR DNA, and true allele DNA, are all of those methods and the methodology that you use generally or widely accepted in your scientific community?
Yes.
Have they been published, the methodology, in relevant scientific journals?
Yes.
Has it been tested, and are those methodologies reliable and reproducible?
Yes, they are.
And were your results in this case, all of your results, peer-reviewed by another scientist?
Yes, they were.
And is that part of the GBI protocols and procedures?
Yes, it is.
And was it followed in this case?
Yes, it was.
I want to start with you let's just go item by item. And we're going to start with the first item, if you don't mind. How about a jacket, item 3 from the crime lab? Did you test, and I've got item 3 here, so one more. Did you test a blue jacket and a cutting from the blue jacket for DNA?
Yes, I tested a cutting from a blue jacket as well as contact swabbings from the blue jacket.
What is contact swabbing?
Contact swabbings are an attempt to attain a profile from someone generally wearing an item of clothing. It doesn't work too well for just touching an item of clothing, but it's someone who has physical contact with their skin and clothing as compared to just testing for bodily fluids.
And I want to ask you that question. So you will do contact swabbing for someone if you believe they wore the item of clothing you just told us. Why doesn't contact swabbing work well for people just touching an item of clothing?
There is a minimum amount of DNA that needs to be present for the testing to be reliable and reproducible. So just touching generally doesn't leave enough skin cells behind to obtain a profile.
I'm going to hand you what's been already admitted as State's Exhibit 147, and there's also a cutting from State's 147. Do you recognize these two items? And the cutting, for the record, is 176, and I'll give you some gloves if you need them.
No.
Do you recognize those two items?
I recognize 176, yes, and I recognize that it comes from the jacket, although I did not handle the jacket myself.
Because that was done by Katrina before you?
Yes.
Okay, there you go, if you need those. And so can you tell us for the jacket, the cuttings from the jacket, which is 150 again? It's right in front of you.
176.
176. What did you do to 176? What type of DNA testing did you do on the jacket, and what were your results? And if we could start first with the traditional DNA with the cutting.
Traditional DNA testing was where we look at the 21 locations along the DNA strand. Do you want me to go through the process or just?
Sure, go ahead just for one. I don't want you to go through the process for every single item, but for the first one, go ahead.
The first step is to extract the DNA from the material. This is used by taking a small cutting, placing it in a tube with chemicals that help separate the DNA from the other biological material. A robot is used in this step as well. The next step is to quantitate the amount of DNA to see if there is human DNA present. We then make copies along the DNA strand of 21 locations we use to compare between individuals. These locations are different in size, and it's these differences in sizes that help distinguish individuals. These fragments of DNA are separated on an instrument called a genetic analyzer, and it is the software from this genetic analyzer that we use. No, it is the data from the genetic analyzer that we use with the software program to type a profile.
When you conducted testing from the cutting of the jacket, that would have been traditional DNA?
Yes.
What were your results?
There was a partial major profile obtained from the cutting from the jacket, and that matched the profile of Laken Riley. There was also a partial minor profile obtained from the cutting from the blue jacket, and that matched the profile of Jose Antonio Ibarra. There are 2 people contributing to this DNA profile.
Now, since this is a mixture of 2 people, why didn't this go to true allele? Why were you able to do traditional DNA testing on this jacket cutting?
We are able to use other methods to separate mixtures into individual contributor genotypes, which is necessary in order for us to say whether a reference sample matches or not. Sometimes we can't separate mixtures into individual contributor genotypes, so that is when we use the software program.
So do you have a threshold at the GBI in which you send items to true allele versus dealing with them in traditional DNA?
Correct.
Okay. And so the cutting from the jacket, did it fall below the threshold where you had to send it to true allele, or was it above the threshold so you could keep traditional DNA?
It was above that threshold, so yes.
Right. And so did you assign a frequency for the partial profile of Jose Antonio Ibarra for the jacket?
Yes, the partial minor profile was 1 in 9 billion individuals.
And this mixture of Laken Riley and Jose Ibarra on the jacket cutting is just the 2 of them?
Yes.
And prior to, I guess I should ask you this, did you obtain or did you have at the laboratory known DNA samples of Laken Riley?
Yes.
Known DNA sample of Jose Ibarra?
Yes.
Known DNA sample of Diego Ibarra?
Yes.
And known DNA sample of Argenis Ibarra?
Yes.
The jacket, does that complete the traditional DNA results on the jacket cutting?
There was a probability for the match to Laken Riley.
If you could give us that too.
1 in 10 quintillion individuals.
Okay. What about the contact swabs on the jacket? What were your results for that? Were you able to do traditional DNA, or did you have to go to true allele?
Those were a complex mixture that had to go to true allele.
Security cameras recorded someone discarding a navy blue jacket into a dumpster on the same day Laken Riley was murdered. In addition, photos found on Jose Ibarra's phone showed him dressed in clothing resembling what the individual in the footage was wearing. Fingernail clippings collected from Riley provided crucial evidence, revealing DNA that matched Ibarra's genetic profile. Experts testified that this type of DNA transfer could only occur through direct physical contact, such as during a struggle or through scratching, further strengthening the case against Ibarra.
Yes, I do. Please take a seat, state and spell your complete name.
My name is Ann Kissler Rao, ANNEKISLER-RAO.
What do you do for a living?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab. And I'm employed as the technical leader of the Trace Evidence Section.
What is the Trace Evidence Section?
Trace Evidence Section analyzes small, often microscopic pieces of evidence, such as hairs, fibers, glass, paints, plastics, and fractured materials.
How long have you worked in that capacity?
I have been employed with the GBI Crime Lab for over 18 years. I've been the technical leader for over a year now.
Over what?
1 year now.
And as the technical leader, do you have certain additional responsibilities?
Yes, in addition to examining pieces of evidence, I'm also responsible for training other individuals in our section and coordinating the proficiency testing in our section and overseeing the analytical manuals.
Are you a microanalyst?
Yes, so part of my job is to perform duties as a microanalyst.
What is a microanalyst?
A microanalyst is someone who analyzes small, often microscopic pieces of evidence like the ones I mentioned, like hairs and fibers.
Would you describe to the court, please, your training and your education that qualifies you for your job?
I have a bachelor's degree in biology from the University of Pennsylvania. I have a master's degree in forensic science from John Jay College. With the GBI Crime Lab, I have completed extensive training programs in hairs, fibers, glass, plastics, paints, and fractured materials. I'm also certified by the American Board of Criminalistics in hair and fiber analysis.
In your career at the GBI, how many hair and fiber analyses have you conducted?
I think it's somewhere over 800 hair analysis and definitely over 150 fiber analysis.
Have you been qualified before as an expert in a courtroom in the field of microanalysis and hair comparisons?
Yes, I have.
Approximately how many times?
I've testified about 67 times within trace evidence, and I think hair was at least 35 of those.
And at this time, Your Honor, the state would move to tender Ms. Kissel-Rao as an expert in the fields of microanalysis and hair comparison.
Any objection?
No, sir.
The witness will be allowed to testify in those fields.
I'd like to turn your attention to your case number 2024-1005-107. Do you recognize that case number? Is that a case that you worked on for at the GBI?
Yes, I do recognize that case number.
And who is the victim associated with that case number?
The victim is Laken Riley.
I'd like to ask you a few things about some of the tests that you did in this case. First of all, were you asked to examine some hairs that were removed from a jacket, which is your item 3 at the crime lab?
Yes, I was.
And what were you asked to do, and what did you observe about the hairs, and how did you do it?
I was asked to compare question hairs that were removed from the jacket to the known head hair of Laken Riley. So in order to do this, I took the previously collected tape lifts of the jacket. I then removed question hairs from those tape lifts and mounted them on microscope slides. I did this using a stereo microscope, which is a low-powered microscope. I then I classified the hairs using the stereo microscope and also a higher powered microscope as to if they're animal or human, what body area they came from, possible ancestry characteristics. I evaluated the root ends of those hairs, and I determined if they were suitable for a microscopical comparison. So typically we will compare head hairs and pubic hairs because they have more distinctive features. I then took the known head hair standard of Laken Riley and mounted that on separate microscope slides. So at this point, I compared the question hairs to the known head hair standard. And when I say known head hair standard, we like to have at least 25 hairs to encompass the entire range of features present on that person's head.
How many head hairs did you have from Laken Riley from the jacket item 3? I'm sorry, how many head hairs did you have that you determined were consistent with Laken Riley? Let's start with that.
So from the jacket, there were 29 hairs recovered from the jacket that I found to be microscopically consistent with the known head hair of Laken Riley, meaning they either originated from her or someone else with hair possessing the same distinct characteristics.
Were you able to make a determination of those 29 hairs? Did any of them have roots?
Yes, they did.
And how many of the 29 did?
So to explain, when we're looking at hair roots, there are basically 3 growth phases. We have anagen hair roots, which are the actively growing growth phase. Those would be the hairs that you need some sort of force to remove from your head. Catagen is the transitional phase, and then telogen is the resting phase, where those would be your naturally shed hairs. So when I looked at the roots, and you can tell the difference by the morphology of the root. So when I looked at the roots, 21 of those hair roots were in the anagen phase, the actively growing phase. The remainder were either broken, and I think there were 2 that were in the resting phase, the telogen phase.
And were you able to form any type of conclusion about those 21 hairs and how they may have been removed from her head?
So because they were in the anagen phase, some sort of force was needed to remove those hairs.
Is it some sort of what?
Force.
Force, okay. And when you explained to us your conclusion that you reached, and I may have misstated it, so I want to make sure you state it correctly. What was the conclusion that you reached on the 29 hairs from the jacket?
So the 29 hairs either originated from Laken Riley or someone with hair possessing the same distinct characteristics.
And how were you able to determine that?
So in order to perform my comparison, basically the basic structure of a hair that you're looking at is the main body of the hair is called the cortex. That's where you find the pigment granules that give the hair its color. Running down the center of a hair is a tube-like structure called the medulla, which may or may not be present. And then running along the outside of the hair is a thin layer of scales called the cuticle. So in order for me to determine whether or not the questioned hairs are consistent with the known, I examine them using the stereo microscope, the low-powered microscope, and then I take them to a comparison microscope. So a comparison microscope is basically two microscopes that are connected together by an optical bridge, where I can put the questioned hairs on one side and the known hairs on the other side and see them at the same time under the same field of view. So when I look at the hairs, I'm examining features like the color of the hair, the pigment granules, the size of the pigment granules, the distribution of these pigment granules, the density of them. I'm looking at the medulla. Is it continuous? Is it broken up? Is it not even there? Is it translucent? Is it opaque? I'm looking at features like the scales and any other microscopic features that might be present. And I will compare those in the question hair to that in the known hair standard as I go from root to tip throughout the hair to determine whether or not the question hair falls within the range of the known.
And you did that for all of your hair comparisons in this case, that process that you just described?
Yes, I did.
And is that process that you just described a generally accepted or widely accepted method of comparing hairs in your scientific community?
Yes, it is.
And has it been, this method been published in relevant scientific journals?
Yes, it has.
And is it reproducible and reliable?
It is.
When doing your comparisons that you just explained to us, and I'm going to move on to other objects, but in doing it, my question is globally for all the hair comparisons that you did in this case, did you follow the GBI's protocols and procedures in conducting your tests?
Yes, I did.
And does the GBI have specific protocols and procedures in how you do your microscopic hair analysis and comparison?
Yes, we do.
Are you familiar with those?
Yes.
And do you in fact train people on those?
I do.
And did you follow those in this case?
Yes, I did.
I want to move on to rocks. Were you asked to look at hairs that were removed from two items? And I'm going to use your GBI numbers again. So for your case number 2024-100510, I want to refer your attention to two item numbers, and I'm talking your GBI item numbers, which would be items 2 and 3. Are items 2 and 3 rocks?
Actually, I think those were our items 22 and 23.
Yeah, sorry. 2 and 3 was the crime scene. Your item numbers 22 and 23, are those rocks from the crime scene?
Yes, they are.
And did you look at those hairs removed from those rocks from the crime scene?
I did.
And what were your results on that? Well, first of all, did you use the same process that you just described to us?
Yes, I did.
And what were your results?
I found off of one of the rocks there were 2 hairs, and off the other rock there were 27 hairs, all found to be microscopically consistent with the known head hair of Laken Riley, meaning they either originated from her or someone else with hair possessing the same distinct microscopic characteristics.
And finally, I want to ask you about a pair of underwear. Were you asked to examine Laken Riley's underwear that was removed at autopsy?
Yes, I was.
And what is your GBI item number for that item of evidence?
Our GBI item number is item 44B.
going to hand you what has already been admitted into evidence as State's Exhibit 321. And open the bag. I want to, yeah, go ahead. Yes. Do you recognize State's 321?
Yes, I do.
And do you see your unique GBI number associated with Laken Riley?
Yes, I do.
And do you see the item number for her underwear?
Yes.
Your GBI item number?
Yes, I do.
And do you see your initials too?
Yes.
Okay, and did you examine that underwear 321?
I did, yes.
And can you tell the court what you did to it?
So for the underwear, I was asked to determine if the damage was a cut or a tear. So I used the stereo microscope, which is the low-powered microscope, to look at the damage and evaluate the features of the damage to determine that.
Did you see, and I'm going to ask you to show it now, did you see damage to her underwear when you examined it?
Yes.
And how did you examine it?
Yes, so I looked visually and then also using that stereo microscope to examine it.
And the damage that you see, can you show the court the damage that you see?
The damage is right here.
In the middle of the underwear. And you were asked to determine what about this damage?
I was asked to determine if it was cut or torn.
How did you go about determining whether it was cut or torn?
I looked at features of the damage. So some of the features that we might observe in something that is torn would be a curling under of the fabric. You might see the yarn ends might be frayed of differing lengths, lying in a different plane, whereas something that is cut would more likely be straight yarn ends that are less frayed. And then also you might see stretching. Also with a knit fabric like this one, sometimes you can see rows of loops that make up the knit fabric remain still intact. With a torn fabric, because they're being torn at the point of weakest structure, whereas with a cut fabric, you might often see that those loops are cut straight through.
Did you perform your examination by using a microscope?
I did.
What were your conclusions?
I determined that this damage is consistent with having been torn.
May I have 1 moment, Your Honor?
Yes.
The defense later suggested that one of Jose Ibarra's brothers might have been involved in the crime. They pointed to surveillance footage showing the brother wearing a black Adidas hat spotted near the crime scene. However, prosecutors refuted this claim by highlighting selfies found on Ibarra's phone and emphasizing the compelling forensic evidence that directly tied him to the murder.
You may cross-examine.
Good afternoon, ma'am. So let me ask you just a couple questions about the hair comparison that you testified about. Well, first of all, I heard you say that that the methods you use are published in scientific journals?
So the methods that we use are recognized throughout the scientific community as acceptable methods, and there is a standard published that describes the methods.
But that wasn't what Ms. Ross asked you, if their methods were published in scientific journals, and you said...
Scientific journals have been published that have used the same methods.
Could you point me to one?
Sure. There's one journal by Hauk and Boudoyle that was discussing the discrimination of microscopical hair comparisons versus the results of mitochondrial hair comparisons.
What year was that?
I don't recall the exact year. It was Journal of Forensic Sciences.
Are you aware of any scientific publications outside of forensic sciences, like an academic science journal that has published a peer-reviewed article on hair comparison?
So most of the hair comparison articles are within forensic science journals that I am aware of.
And that is, those are the scientists like yourself who testify in court.
Some of them might testify in court.
But I mean, that's what forensic science is. It's right. It's the use of the application of science to legal investigation in the courtroom.
Yes, and there are people who work at universities who also work within the forensic science team.
Okay. I read about one FBI study from 2002. Are you familiar with that one?
Could you explain?
Well, it's the one where they found that in 80 cases that there was an 11% error rate based on the comparison that the microscopic hair examiners had compared against when the mitochondrial DNA was examined.
So that's actually the article that I mentioned. So yes, they did find that about 90% of the hair comparisons were in fact verified by a mitochondrial DNA exam. Of the ones that were not verified, a lot of them were more lightly colored blonde hairs that had less features for comparison.
But it did conclude that 11% of the examiners were wrong in that test.
I would not say wrong. That's just showing the limitations of this particular examination. So they did show that about 90%, they said about 11% were shown to be, did not actually support the microscopical comparison.
And so, but I'm not sure if I'm using this word right, the control there was the mitochondrial DNA testing.
They were just comparing basically the two examinations together to see what the results were from the mitochondrial DNA exams versus the microscopical.
You would agree that the mitochondrial DNA testing is going to be a lot more accurate than the hair comparison?
I would not say more accurate. So mitochondrial DNA also is not an absolute form of identification, and there is actually the potential for hair exams to distinguish individuals that mitochondrial DNA cannot.
And in a number of the hairs that you examined, the lab would have had the ability to go beyond the mitochondrial DNA testing to the full DNA profile testing.
So yes, there's sometimes potential for nuclear DNA testing.
And you even note that in your report that, hey, if you want to go further and either get other results that could confirm this test or eliminate Laken Riley as a potential donor of the hair, that DNA testing is available.
Yes, that's correct. That's possible.
That's all. Thank you.
What color was Laken Riley's hair?
May I refer to my notes? So I have it described as a medium brown, and then a lot of her hairs, the longer hairs, got lighter towards the tip of the hair.
That's all I have. Thank you.
Anything else, Mr. Godwin? No, sir. Okay. Was she excused?
Yes, sir.
You're excused.
Over 4 days, prosecutors built their case by presenting DNA evidence linking Jose Ibarra to the crime, surveillance footage of a man resembling Ibarra discarding the jacket, eyewitness accounts of someone in a navy blue jacket near the trail, and selfies from Ibarra's phone as further proof of his involvement. The defense challenged the DNA evidence, questioning both its quality and the interpretation of the results. They argued that any reasonable doubt should lead to a not guilty verdict, no matter how unlikely. They proposed an alternative theory, suggesting that Ibarra's brother could be the actual perpetrator, pointing to surveillance footage they claimed showed the brother, not Ibarra, disposing of evidence. On November 20th, 2024, Athens Clarke County Superior Court Judge H. Patrick Haggard found Ibarra guilty in a bench trial. He was convicted on 10 charges, including murder, kidnapping with bodily injury, aggravated assault, and tampering with evidence. Judge Haggard sentenced him to life in prison without the possibility of parole.
In the state of Georgia versus Jose Antonio Ibarra, case SU 24CR0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder, I find the defendant guilty. Count 3, felony murder, I find the defendant guilty. Count 4, felony murder, I find the defendant guilty. Count 5, kidnapping with bodily injury, I find the defendant guilty. Count 6, aggravated assault with intent to rape, I find the defendant guilty. Count 7, aggravated battery, I find the defendant guilty. Count 8, obstructing or hindering a 911 call, I find the defendant guilty. Count 9, tampering with evidence, I find the defendant guilty. Count 10, peeping Tom, I find the defendant guilty. I certainly will allow both sides to look at this if you want to do it.
During sentencing, Laken Riley's mother, Allison Phillips, gave a heart-wrenching statement about the profound loss her family had endured. She said, "This monster took away our chances to see Laken graduate from nursing school. He ripped away every beautiful memory we can ever make with her again." Riley's roommate, Connolly Huth, also spoke about the lasting impact of the tragedy. She shared how it shattered her sense of security, admitting she no longer feels safe running, as fear now overshadows what was once a source of joy. The case sparked renewed national debates about immigration and crime. In response to Riley's murder, Georgia lawmakers enacted a new immigration enforcement law. The legislation requires officials to verify the immigration status of individuals who are arrested or detained, aiming to address public concerns about violent crimes involving undocumented migrants. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.